Welcome back to our series of videos from Mastering Trial Advocacy 2nd Edition. I want to talk with you now about moving into dealing with expert witnesses. And first we're going to talk about presenting an expert witness effectively and using them for their true purposes of educating the jury before we move into talking about cross-examining an expert and the things that we need to get taken care of there. So when we think about presenting an expert witness, we need to recall back to why they are able to say the things that they are able to say in court. The purpose of an expert witness is to take a highly specialized topic or area and use them to educate the jury about that topic or area that is essential to the charge or claims that have been brought before the court. So when we do that, we need to tell the jury why the expert is here. If we're in an accident and we have an accident reconstruction expert, we need to explain why they're necessary to really understand that car crash. If we're dealing with a mental health expert in a criminal trial, we need to give them the foundation and understanding for why that person is there. We talked in direct examination about asking the witness, why are you here to testify today? That question is even more important when we're talking about an expert witness. It helps to undercut the issues of bias that they're being paid for their testimony somehow, and it also gives the jury the frame of reference. This person is here to serve a purpose for me, the member of the jury. We need to establish the foundation for their expertise, making sure we hit the Daubert factors under 702 and 703 such that they are able to render the appropriate opinion. We need to know our jurisdiction, to know if we need to tender the witness or simply lay the facts for their expertise and then move into their opinion section of the testimony. Speaking of the opinion, we need to provide that major opinion up front and then get into the individual facts and data that they reviewed in order to come to that opinion. We have to explore the basis for that major opinion, keeping in mind the crucial caveat of Federal Rule of Evidence 705, which, as we all know, says that an expert can rely upon otherwise inadmissible hearsay in coming to their conclusion. What an expert cannot do is become a conduit for that otherwise inadmissible hearsay. People get this mixed up all the time. So you as an advocate need to prepare to not use the expert in that impermissible fashion, and you also need to be on your toes waiting for opposing counsel to attempt to do so. You need to discuss weaknesses that exist within your expert's case. Say that they're an accident reconstruction expert because when they were young, when they were younger, their sister died in a car crash caused by a drunk driver. If there's an area that's really going to get blown up on cross-examination, you need to draw the sting first and foremost. You got to come out, you've got to have the conversation, and you've got to do the best that you can to protect your witness. Finally, we want to restate that major opinion and keep in mind that they can testify to the ultimate issue of the case so long as it is phrased as follows. It is my opinion that. They can't tell the jury, you should find. It is my opinion that. That allows us to embrace the ultimate issue of the case. It allows us to use the expert effectively. Now, when we're presenting the expert, some things to keep in mind for presentation. You are using your expert as a teacher. Most experts function best when they have the opportunity to teach on the individual thing that they love so much they've spent their lives becoming an expert on it. So use them to your advantage in that fashion. If they are dealing with a highly complex or intricate technical matter, you should allow them to educate you. The way that you take this to the next level is to talk with the expert beforehand and say, look, when you start talking about these complex things, I'm going to say that I'm confused. Understand that I'm not because I've done the case analysis, but I don't want the jury to feel like they are somehow stupid, ignorant, or unworthy because they don't understand it the first time that you explain it. Go back and rewatch the videos that we've done about exhibits and talking about step-downs. Step-downs with an expert witness are a great way to communicate these highly technical points and use them to your best fashion. Experts, when used well, can make your case so much more persuasive, so much more understandable, and really enhance what it is that you're doing.
I want to talk with you now about cross-examining the expert witness. And as we begin to have this discussion, I want you to remember two things. It's an expert. Another way to think of that is that an ex is just a has-been who used to be really good and important at something. And a spurt is nothing more than a drip that's under pressure. There's no reason for us to be afraid of experts. We respect them. We respect their expertise, and we strive to confront them appropriately, but we do not need to have fear. Fear is not useful when cross-examining an expert witness. You can think of the cross-examination of an expert witness as though I were on a desert island in the middle of the ocean. I'm on a small island. As the lawyer standing on the island, I'm safe. The island are the specific facts of this case and the law. I'm surrounded by the water. That's the expert's opinion. The expert is like a shark swimming in the water. I don't want to go in that water because it's not safe. As long as I'm on the island of the facts of this particular issue and the law, I can cross-examine all day long because that's my expertise. That's my bailiwick. That's where I have the most power. If I'm going to get in the water of the expert's opinion for cross-examination, I'm going to bring a bang stick with me. I'm going to bring something that's going to allow me to take care of that expert opinion. And that bang stick could be something as simple as facts that bolster my theme and theory, facts that build up the credibility of my witness, or tears down the credibility of what the expert is relying upon from an evidentiary perspective. And I want to cluster together all the facts that help my particular topic on cross-examination. And I lay out those facts one question at a time leading up to my point. It's important that I do that with experts. And you should not forget that experts are people too. They have the same issues of bias, motive, and prejudice as anyone else does. Do they always testify for the plaintiff? Do they only testify for the defense? Are they a prosecution darling, or are they a criminal defense lawyer's darling? If they're not impartial, that's fair game. If they're getting paid, that's fair game. If they have shown themselves to not be credible, that's fair game. At the end of the day, it's just like any other witness, but you really have to take your time and stay on the island of the facts.